attendees take away from today's webinar? Judge Waxy, let's start with you.
Well, I think the main thing they should take away is don't forget about Rule 1, because these rules are set up to get matters resolved in a just, speedy, and inexpensive manner. The rules are not there to provide lawyers a setting where they can play games with litigation or try and make lots of money without regard to their clients' needs for just, speedy, and inexpensive. So if you get the focus on just, speedy, and inexpensive, and the idea that cooperation is one of the best ways to get to just, speedy, and inexpensive, I think you'll be way ahead of the rest of the crowd.
Steve Bennett.
Yeah, I think the opposite side of that coin, and it's the same coin, is a recognition of one's own limitations. We are talking about ever-evolving technology. We are talking about circumstances where the client's capacity to manage information can be highly variable. The worst of all possible worlds, it seems to me, is to whistle past the graveyard and assume that just because something hasn't come to light yet, everything's in order. Having a system that is designed to get at the substance of what the client has and how they're managing it, and staying on the client to make sure that is getting done, and also bringing in the expertise in circumstances where you as a lawyer may not have full knowledge or understanding of the technology is really important. The worst of all possible worlds is to both be ignorant about something and less than humble in your approach to it. And that also goes for circumstances where mistakes arise and people try to cover them up. Almost inevitably, in the cases where sanctions are ordered, somewhere along the line somebody realized that things were messed up and then didn't own up to it in a forthright way.
Judy Selby, you get the final word.
Oh, great. Well, I guess I'll follow up by saying that a documented strong cybersecurity practice for law firms has gone from should to must. And I'll raise one point that I forgot to mention during my presentation, and this is something that unfortunately I have heard lawyers say that, I have a clawback agreement, so, if I inadvertently produce something because I don't understand technology, I'll just get it right back. And that's not always the case. And in fact, in the Wells Fargo case, the defendant said the plaintiff's attorney actually tried to use the inadvertent disclosure to their advantage in the litigation. So don't count on that. The ethical rules and the federal rules kind of require lawyers to understand the technology that we're all forced to work with now. So it's really a very important part of the job now.